John Willding, we're so delighted to be with you in person, and I put on a tie today for the first time in a really long time, so hopefully it looks okay. But you know, in the world of mega law firms, you sometimes have partners that you've never met and you may have been on a phone call with, but I have the pleasure of working with Doug Haloftis for the last 6 years on dozens and dozens of complicated matters. Doug is an employment lawyer. I'm a business lawyer. I help people buy and sell companies, and I advise boards of directors on their fiduciary duties. And I suspect that a number of you also advise your boards and have had to deal with COVID in a multitude of different ways. But Doug is going to cover pretty much all of the laws, and they change about every 3 days. So, you know, check back with us. We're always welcome to get your calls and to just, you know, be a resource for you. But one of the things that Doug and I talked about recently, with all of the myriad of issues, the myriad of executive orders, the myriad of stays in courts of appeals, is what does the board of directors do with all of this? The reality of it is, and one of the things I want to emphasize is, once you bring it into the board, it's in the board, and it's in a director subject to the fiduciary duties of a director. And this in the slides, and most of what we're going to cover is really related to employment matters, vaccine mandates, what can you do, what can't you do. But I want to introduce and preview this issue and responsibility of a board member. And so, as you know, board members typically have the principal duties of loyalty and the duties of care. And at play here really is the duty of care. And I just want to read this, the only thing I read here, but you should think about this. If you're advising a board, if you're on the board yourself, you know, I can assure you that just turning on the television and listening to Dr. Fauci, whether he's a good guy or a bad guy, is not going to fulfill your duty of care. And so the duty of care requires informed, deliberative decision-making based on all material reasonably available. And so what that doesn't mean is you sort of take the path of least resistance. You just say, there's a lot of stuff being mandated. We're going to push it out to everybody. We're not going to figure out what the different courts are saying. We're not going to consult with an immunologist. You know, most of the boards don't have experts in infectious disease. And so, you know, some of these things can really impact not only decisions about employees and whether things like workers' comp apply, whether at-will employment applies, but also whether a director has fulfilled her fiduciary duties. So I'm going to sort of transition to Doug, and what I'm going to do, so Doug and I have worked together, like I said, on a lot of different things. And Doug is an encyclopedia on all things employment law. I am that curious, annoying person that says, yeah, but what if this, what if that? Doug, are you seriously telling me that, you know, we could take a vaccine and force someone to get it? And what if they die? Or what if they, you know, what if the board doesn't do this? So I'm annoying, but it's sometimes helpful to our clients. So how do you want to start? There's so much.
Well, thank you, John. Thank you for that introduction. And I thought I would start today by looking at a little ancient history going back 6 months, 3 months to kind of figure out how we got there. And then we'll see how all of this sort of accelerates into things that were changing as recently as yesterday. So with respect to the ancient history, you know, you might think back, a year or two ago when we didn't have vaccinations, we weren't sure how to deal with the risk associated with the pandemic, as another law that sort of dovetails with what John was talking about with respect to these fiduciary duty issues at its most basic is Section 5 of the Occupational Safety and Health Act, which people forget about it, but it's been around since 1970. And it is the employer's duty to keep employees safe from risk of harm or death. I mean, it's the central statute that drives all of the work of OSHA. And so an employer has this duty of, oh, what's happening here in the workplace that might be a risk to employees that might cause them death or harm. And of course, we have duties to visitors and other people that come on the property. So you think back to what we were doing less than a year ago. People were requiring folks who came on the premises to sign waivers. We were working remotely. We didn't know who had to wear a mask, and then we didn't know if vaccinated people had to wear a mask and unvaccinated people had to wear a mask, or did vaccinated people have to wear a mask when they were meeting with unvaccinated people. So we saw people sorting through all these issues. And of course, we had clients that way before the emergency temporary standard came out in November, were already imposing mandatory vaccination requirements. So if you were concerned about exposure to third parties or to your employees to COVID and getting sued for it, well, then Governor Abbott and the Texas legislature stepped in June and implemented the Pandemic Liability Protection Act. And it really preempted all common law claims in Texas for exposure to COVID, except under the act. And it provided these very high bars to pleading and proof. So for someone to sue for death or injury related to COVID exposure, they have to prove that the defendant knowingly failed to warn or remediate a condition that the defendant knew was likely to result in exposure to COVID. That's not easy to do. And then they have to be able to plead scientific evidence. They'd have to hire a consultant, an expert that would give them information and data that says, oh yes, this is when you were exposed to COVID. And this event at which you were exposed was the cause, in fact, of your infection. So that is an enormously high bar. I'm not saying it can't be done. Maybe if you're working in a chicken processing plant or a nursing home, you could meet this standard. But other than that, I have not seen any third-party cases filed in Dallas County for exposure to COVID. So that should put people's minds.
The context of that, I think, takes us back to March of 2020. The whole world shut down. This fiduciary duty topic began to pop up because companies were shutting down every day. They were going out of business, and directors have duties with respect to maximizing shareholder value, these other issues about a safe workforce. And I think Governor Abbott came in because employers, which are risk averse in general, were confronted with, what can we do? Can we even have anyone come into our office? Are we going to be inundated with lawsuits? Is our company going to be shut down because someone got COVID? We don't know whether they got it in our office. How do they prove it? So my understanding in there is that the state of Texas at least tried to give employers some protections from, and to keep, literally thousands of lawsuits from being filed in the Dallas County courts.
Exactly.
Is that
exactly
fair?
That's fair. And not just Texas. You'll find these pandemic protection laws in the majority of the states. Most of the legislatures took some action because it was an area of concern. And again, even before this, if you looked at the COVID tracker of cases, I didn't see maybe out of the 2,000 cases that were filed in the first 12 months of COVID, only about 150 of those cases nationwide dealt with exposure to COVID. The vast majority of them dealt with insurance claims for business interruption from COVID.
Right.
So,
right. Which I'm sure many of you saw this. Certainly middle market companies saw this a lot, where they had purchased business interruption policies, and they clearly had a business interruption. If you're an employer, if you're an insurance provider, they tended to not like how you were interpreting business interruption. And so that became the bulk of what a lot of the outside counsel were dealing with, is how do we make a claim against our provider? How do we, and then obviously the triple P loans, were going wild. You know, many people got those, and it created a sort of a environment where everything was, how do we keep people employed? How do we keep the doors open even though nobody's going into the offices? And then over a period of time, the pendulum began to switch into, well, you know, this is going on a lot longer than we thought. We have to actually come into the office. And then also the concept of what is an essential worker was a huge issue. I think I got calls a day. You probably got dozens of calls a day on, can we operate? Can we even go into our office?
Right.
So
what do we have to do?
Ancient history in this context is 1 year.
Exactly.
Right.
Oh, exactly. And now we're going to fast forward to basically November. And well, around June, July, the Biden administration is making announcements about issuing certain executive orders, and then various groups within the government are going to spring into action to meet certain objectives that were set out by the administration. The government wanted to keep its citizenry safe, wanted to improve our vaccination rates up into the 80% nationwide. So it begins to think about these executive orders that it's going to issue. It wants to increase the number of vaccinations. It wants to protect the unvaccinated. It's interested in school safety. And of course, the Centers for Medical Services have been all over this from the beginning about healthcare providers, what kinds of policies and orders are in place for people in the healthcare industry, hospice, and nursing homes. Masking is part of this discussion. And again, it's all driven to restarting the economy and getting things going again. And here is what they come up with, the administration. That first bullet point is the so-called ETS, the Emergency Temporary Standard, which was going to go into effect November 15th and November 5, something like that, and basically gave employers, November 5, 30 days to make sure that all of its employees were vaccinated. And so that's the ETS. President Biden signed that order as of November 15th, was stayed by the Federal Court of Appeals nationwide injunction. So that order is issued on, I think, the 15th, and the next day it's stayed by the Court of Appeals.
So let's emphasize that. So you're saying that President Biden had an executive order. This is applying to companies with more than 100 employees, and essentially was a mandate for vaccination. And then within a period of a few days, there was multiple challenges that went on accelerated review to the Fifth Circuit and other circuits. And so, and this was in November. And then so as we stand, and then alongside that, Governor Abbott, I believe, issued another set of orders similar to what Governor DeSantis has done in Florida, which is, you know, telling employers they can't have a mandate. Is that
correct? And we'll see all of this in a little bit greater detail, but that's exactly right.
Okay.
I like to put that context out front because as we go down this list, everything that I was going to talk about today was stayed effectively as of yesterday. So it doesn't mean we shouldn't do anything about it. It just means that ancient history can be a week on this road trip we're taking. So as John pointed out, the governor is going to step in here in a minute. So the first one, the ETS, 100 employees or more, with some exceptions, you must have your workforce vaccinated. A lot of people, again, before that was issued on November 15th, were preparing, trying to get ready, and we'll see how people were preparing, because you still might want to. You don't know how the story is going to end. The President Biden signed an executive order requiring that all federal employees be vaccinated. That order is still in place. Of the four orders that are listed on this slide, that is the only one that remains in place today. Now, that doesn't mean an employer may not still have a mandatory policy. I mean, depending on what state you're in most states, the employers could have a mandatory policy. But in some states, they're going to have to proceed with caution because, as John pointed out, of governor or legislative orders. The executive order requiring certain federal contractors to be vaccinated and subcontractors that went into effect again in early September, actually, to begin the processing of it. Now, you'll see in a minute when we look at the details of that, that if you were a federal contractor, it didn't mean you immediately had to have your whole workforce vaccinated. You had to wait for it to be contacted by the applicable department that you contracted with the government. They would give you a so-called deviation clause. Then you would agree to this change to your contract, and then it would go into effect. But around December, the plan was that if you got one of these deviation clause provisions, you needed to have your workforce vaccinated. And we'll see, depending how far we get in the slides, that as of a week ago, if you were in Kentucky and Tennessee and another state, that executive order regarding federal contractors was stayed. And then yesterday, a federal court in Georgia stayed the order nationwide. So if you were not quite ready and you're a federal contractor and you hadn't signed the deviation clause, you're kind of off the hook, at least at the moment, while these issues work their way through the court system.
So let's talk about that. So I think what you're saying is the federal government put a vaccine mandate out for federal governmental contractors. Is that right?
Correct.
And then these court matters proceeded, and ultimately yesterday, they put a national stay on that order, meaning you can't enforce it during the review period, something like that, or?
Yeah, the Department of Justice could not enforce the order.
So, but what if a company wanted to have a vaccine mandate policy just because they feel it's in the best interest of their company?
And that would be,
No matter where,
assuming you're not in Montana or Texas, and perhaps Tennessee, depending on how we look at that order, you could lawfully impose a mandatory vaccination mandate in your workforce, in your workplace.
So like in Texas, though, for example, and this isn't a federal contractor issue, but so we have the stay on the federal requirement of vaccine mandate. We have a governor's order in Texas, which Doug will tell you more about, that says you can't mandate. And then you have companies that have to make decisions. And, just recognizing that there's a lot of people that have strong opinions about mandates and you should have them because people are going to die if you don't. And you have people have very strong opinions about their civil liberties and that's fine. This is America. We can have these different opinions, but if you're in a board, you're making these decisions, you have these fiduciary obligations. You have to have a process that's well informed. You have to consider all the information. You have to be knowledgeable about these court cases. You probably, if you're going to impose a vaccine mandate on your own, consult with an immunologist or some kind of other healthcare expert to advise you on these decisions that you're going to make. And so in Texas, let's say you just go forward and have a mandatory vaccine, a mandate of your own, a policy. Well, you are now violating the Texas governor's order, and you're getting into all kinds of issues with your workforce. So a lot of your workforce is going to be at will employees, and you may be able to do certain things with them that you can't do with somebody that has a written employment agreement. So if you have a written employment agreement, you got to look at the definition of cause, right? Because the other side of this is we're making you get a vaccine. The other side of it is if you don't get it, you're fired, right? We'll give you 3 weeks, you're fired. Well, if you're fired and you have an employment agreement that has a very narrow definition of cause, then you probably have a claim against the company under your employment agreement. And if the board just turned on the TV and watched CNN and Dr. Fauci and did nothing else, didn't consult with any medical experts, didn't consider any of the governor's order, didn't consider these federal cases, you very well may have a breach of fiduciary duty. And then you have to get into questions of, well, who do the fiduciary duties run to? Well, normally they would just run to the shareholders. But in the employment law, with some of these health and safety issues, they can also run to employees. And a lot of people don't know that. And so, you know, you could have a situation where you impose this, somebody gets the vaccine and they die, or they get paralyzed, or you have a situation where, and this has happened for sure. I mean, and then you could have another situation where if you don't impose the mandate, then you have employees that are claiming that they have an unsafe work environment. So I'll stop, but there's a multitude of things. And, you know, from a corporate lawyer's perspective, you just really better make sure if you're on a board that you're taking things seriously and you're documenting it and you're consulting it. All decisions have consequences, and all decisions will have people that think you made the wrong decision or the right decision. But to fulfill your fiduciary obligations, you know, you need to be consulting with doctors, lawyers, figuring out what the landscape is, and then recognize that it's changing quite frequently.
Exactly.
Right.
Exactly.
In the federal contractor context, you said that if the contractor hadn't signed the deviation clause, so even though the executive order has been stayed, if the contractors now amended their contract willingly with the government, are they now bound by that?
I don't have a case on point because of that injunction was issued yesterday, but that I really thought that through when thinking about what I was going to say today, because I thought initially, oh, did the injunction purport to even limit the enforcement of the vaccine mandate for contractors who have signed the deviation clause? And I don't believe it does, because already if you sign that before the injunction was issued, then you've already agreed to it by contract. I think the federal court in that circumstance, the people who brought that action in Georgia, they were claiming, oh, we don't want to comply because they hadn't complied. I think if you've already gotten that clause and signed it, I think you're not going to, you'd have to bring your own action and bring that test case to see, but I don't know what basis there would be for overturning it at this point.
So that situation is one in which you had contractors and subcontract. I mean, this went to, you know, there's quite a chain here, but so this deviation order, a company is agreeing to do what or to not do what?
So they've signed a contract with the government, but the contract they signed says nothing about mandatory vaccinations for its employees or subcontractors. So the executive order requires their department, because not all federal contractors will be subject. You could be a federal contractor, never have to have a mandatory vaccination policy, but it was all decided by this federal administration regulation committee and council. They would get together, they would charge what departments, whoever had contracts from various departments, who would have to issue this requirement, this mandate, and then to effect it, it required an amendment of the contract with the so-called deviation clause. Deviation clause being, you will now vaccinate your employees. You sign it, it's now effective. You don't sign it, assume you don't get the contract anymore. The contract goes poof, it's ended.
Right. And so as the annoying person that I am, I would say, you know, that's under duress. I mean, come on, you're telling everybody that they're going to have to, you know, they're going to lose all their contracts, these, you know, super huge government prime contractors, these subcontractors that depend on these contracts. And that, you know, I would argue that they really had no choice if they wanted to work for the government, and, you know, to have to make these kind of decisions in the context of a pandemic, and that, you know, what else would be duress?
No, and I think that was exactly the basis for the injunction, because the argument was, oh, the executive order is under-inclusive, it's over-inclusive, it's, you know, it's way beyond your regulatory powers to regulate procurement. You're now requiring 15 people to get a vaccination. That's not regulating some aspect of a defense contract. And the other issue was it was an unconstitutional delegation of legislative authority or a usurpation of of legislative power by the executive branch.
Right.
So,
Okay.
so in the meantime, though,
So we'll wait for another lawsuit.
for the one who's actually signed the exactly.
Okay.
Governor Abbott had something to say on these issues, really in response to the proposed emergency temporary standard. And that's when he issued his executive order GA 40. And it says right there, no entity in Texas can compel any individual, including any employee or consumer, to receive a vaccination who, and this is a new objection, who objects for any reason of personal conscience. The prior reasons for an exemption from a vaccination mandate by a private employer was a religious accommodation or a disability. Those were mandated by federal law, either the Civil Rights Act or the Americans with Disabilities Act. But this new exemption sort of really opens it up completely to any matter of personal conscience. And so when the order was issued, and then once the emergency temporary standard was stayed, I've generally advised clients in Texas that they can no longer implement their mandatory vaccination policy without being at risk of violating the governor's order. And you'll see on the next slide that it's a penalty of $1,000 per day per violation. I haven't seen any enforcement actions in the private setting yet, but it's just a matter of where you want to be on the risk curves. I think some of the major employers that drew lawsuits for requiring mandatory vaccinations, like one of the airlines, they've just decided to take their chances with the governor's order and have continued to require vaccinations. Now, they may have changed that in light of the stay on the order regarding federal contractors, but it is an issue. It would be the same issue in Montana. So you'll see if you're a multi-state employer, you may be able to keep your mandatory vaccination policy if you have it in multiple states, but you may not be able to keep it in Texas.
And that applies to consumers of the business too. You can't tell somebody that in Texas that you have to have a vaccination card to come in and have lunch here.
Yeah, I had a
Right.
national retailer called very
Yeah.
upset about that yesterday because they were ready to require their customers to have their vaccination cards to come in. And they were not happy to learn that, you can do it in Texas, but I don't know if you want to pay the $1,000 per day per violation. It could add up. It just seems like a really bad idea to me. So now the other thing, if you were, and I had a few clients that long before the ETS, they said, we want the mandatory vaccination policy. Not huge employers, 300-400 employees, but we're going to do it. We think it's the right thing to do. And then as you saw, go back to ancient history, Judge Hughes's order out of Texas, his federal judge, said, look, at will trumps all these issues. If you're an employer, you can require people to wear purple socks. And if they don't wear purple socks, you can fire them. You can require people to get a vaccination and they don't get vaccinated, as long as it's not discriminatory or not a violation of a medical or a religious accommodation, you can fire them for it. And so some of these employers that went down the road, put their policies in place, all of a sudden the governor orders comes along. And they said, well, and I said, well, look, what are you going to do? You're here in Texas. Are you going to keep the policy in place? Or are you going to let it up? And they're still sort of wringing their hands on that. And the one argument, I don't recommend it, but if you're one of those employers that have your mandatory vaccination in policy, you don't want to comply with the governor's order, then there is an argument that the governor's order says you can't compel someone to get a vaccination. All these federal court decisions say when you fire an at-will employee for not getting the vaccination, you're not compelling anything. They're free to go to work wherever they want. They're just not free to work here anymore because they didn't get the vaccination. But it's still their choice to get it or not get it and not work here. So we may have there is an argument, if you're there, that you're not violating the governor's order because you're not compelling an at-will employee to get the vaccination. You're just telling them they can't work here any longer without it. They said, I don't recommend it. It's not a great argument, but it's the
Yeah,
best
if I
can-"
was ever a federal judge and got that case. You have a question?
What are your thoughts on, rather than a compelling, or getting that vaccine terminated, but rather structuring it that if you don't get the vaccine, your insurance premiums on a monthly basis are going to go up by X, and you're also going to be required to submit to
A week.
on some frequent basis. Is that, you haven't seen this challenges to it yet, does that get around it?
Well, I think, and you'll see if we get later on in the deck, those are all good ideas. And as long as I think the conditions for not getting the vaccine were not so coercive that it would constitute compelling under the governor's order, I think those are all excellent ideas. And that's really kind of where I think we'll end up today in our discussion. That if you want to comply with the governor's order, but yet you want to have as many people in your workforce vaccinated as you possibly can, then you're really looking at that hybrid approach where we strongly recommend vaccinations. But if you don't get vaccinated, then we're going to have weekly testing, which is required, which is an alternative under the emergency temporary standard. You have to wear a mask. You have to buy your own mask. You have to pay for your own test every week. Your health insurance premiums may go up. All those things are perfectly appropriate. And I see a lot of clients dealing with trying to structure those and react as things are changing. And again, I want to be clear, the governor isn't against vaccinations. I mean, his order says we strongly encourage vaccination. We just think it's a matter of personal choice and shouldn't be governmentally mandated.
And they've all been vaccinated, Donald Trump, Mike Pence, Greg Abbott, Ron DeSantis. These are all people that have been vaccinated. They just have a different opinion on mandates.
We're going to talk a minute about what the ETS, if let's say it does go into effect, what it covers. Employers with more than 100 employees, full-time employees, part-time. This is different than the discrimination laws. Normally a statutory employer is someone with 15 or 20 employees, depending on the law. And they're usually people that have worked for the company 20 weeks or more during an applicable period of a year, for example. Here, this is if you reach that 100 employee threshold at any time, within any time period, all of a sudden the ETS kicks in, you're subject to it. It's calculated on a firm or corporate-wide basis. It's been true. I've had this question on the bottom point on this slide. If you're a group of companies, you have 10 subsidiaries and each subsidiary has less than 100 employees, do we aggregate the subsidiaries within the holding company? And the answer to that appears to be no, unless there's a commonly controlled safety policy, because this is administered under OSHA. Normally citations are issued to the entity that was involved in the citation event, the thing that triggered the OSHA citation. And sometimes a subcontractor's violation can trigger a citation to the general contractor, but that is only where the general contractor controls the safety policies on the job site. So OSHA has always had a system of respecting how things are corporately organized for citation purposes. So this has been the guidance and the interpretation that if you have 10 subsidiaries and they all have less than 100 employees, you will not be subject to the ETS.
Does OSHA regulate all companies in America, or do they have to be of a certain size?
So we have sites that are regulated by MSHA, and there's sites regulated by OSHA that are next to each other. So we have two different standards.
And the two standards conflict?
Oh, yeah. Yeah, MSHA has not joined OSHA. OSHA
Well, I don't know the answer to that.
So I don't know what MSHA is.
Sorry, it's OSHA for mining.
OSHA for mining. How did I not know that? Is this crypto mining or is this like a real mining? Thank you.
Yeah, we'll talk offline about that because that's, I mean, that would be two federal agencies. Not being able to quite get the standard consistent. The exceptions to this emergency temporary standard, obviously federal contractors and subcontractors, they're subject to their own executive order 14042. Healthcare providers, that was subject to the CMS executive order. So they're not subject to this. They might have to implement mandatory vaccination policies had the orders not been stayed, regardless of the number of employees they had. And then otherwise, employees who work remotely completely, never report to the workplace, they don't have to get a vaccination if you were subject to the ETS. Or an employee who worked exclusively outdoors. Now, I've not had any clients who had any employees that met either one of these exceptions, but that would be an exception for a mandate to an employee that worked for one of these employers subject to the ETS. Now, ETS, unlike the executive order regarding federal contractors, is an either or proposition. It says you must have all your employees vaccinated. And at the time, it didn't require booster shots. Or you can do the weekly testing every 7 days of your workforce. And you have to require unvaccinated employees to wear a mask if they're in any sort of group or social setting outside of their office at the workplace. So this is another reason, and you'll see it later, why I think that even if the ETS survives in the federal courts and remains in place, it may not preempt Governor Abbott's order, because you could still comply with Governor Abbott's order by not requiring the vaccinations, but by doing the weekly testing. That doesn't sound like a great, I mean, to me, and I'm not an employer, I just think the weekly testing, depending how large of an employer you are, is just an administrative nightmare to keep track of it and track it and see who's gotten their vaccination and who hasn't, and following up with people, keeping the records segregated. It's not a great option, but it may be the only option that we're left with, you know, if the governor's order stays into effect. Acceptable tests, any that are cited in the order, they can be self-administered, but if they're self-administered, they have to be observed by the employer or an authorized telehealth provider. And and there are a lot of services popping up. If you're on the Society of Human Resources Management website, you'll find lots of ads from providers that can help you with these services of monitoring weekly testing, providing weekly testing, monitoring self-testing.
And one thing I think to highlight is that, we have had a complete sea change in a period of 1 year. My whole legal career, employees' healthcare information was protected by HIPAA. There was huge safeguards. Employers would virtually never get into your healthcare or require certain things. And this is just kind of flipped upside down. So you've got this myriad of health and safety issues. You've got the states' rights versus federal rights. And then you've got, the sort of confidentiality of your personal healthcare information that has created a real mess. So Doug, if I came to you, you're the CEO, you're on the board, and I work for you, and I say, Doug, I can't get the vaccine because I have a healthcare condition. And you are a great lawyer, and you probably have some business skills too, but are, what do you have to do? Can you just say, no, John, I'm sorry that, your Botox is not a sufficient reason to, that the RNA vaccination is having some complications with that. What do you need to do? Can you just tell me yes or no? My heart condition is good enough, but your, cancer is not. What happens there?
No, you're exactly right. With the CARES Act and these mandatory vaccination issues, there really was a watershed event, because generally we started, if we could rewind the clock pre-COVID, all medical inquiries, unless they were job related and are consistent with business necessity, were prohibited. So unless all pre-employment medical inquiries were generally prohibited, unless they were job related and consistent with medical necessity. So for years, since the 90s, people ran their workplaces with the idea that we cannot ask about anyone's particular health status at any time. And then all of a sudden we needed to know about vaccinations. And the EEOC said, oh, well, that's not a medical inquiry. Vaccination is not a medical inquiry. All you can ask is, are you vaccinated? Are you not? Don't ask, why aren't you vaccinated? Or how come you can't be vaccinated? You'll need to follow our normal ADA requirements for those kinds of inquiries. And again, this notion of, if someone needed to lift 50 pounds in their job, of course, we could provide tests for those kinds of things. They were job related, they were consistent with business necessity. A non-medical professional, but sometimes, but maybe not always, could provide those examinations, and they were lawful. But here, now it's gotten pretty tricky. As John pointed out, if we have a mandatory or even a strongly encouraged policy, we have to have these exceptions for medical contraindications, a disability, and the like. And that required, so really when people were forming these mandatory vaccination policies, they would have to engage an outside immunologist or infectious disease specialist to guide the inquiry. Usually as part of the fiduciary duties that John were talking about, the infectious disease or the immunologist would say, yes, for safety purposes, it is medically necessary that we have this vaccination policy. And then this consultant, we would rely upon them as the accommodation request would come in, the nursing mother, someone who was pregnant, someone who had claimed a past medical history of adverse reactions to vaccinations. Then the HR department would have to spring into action. We can't have the manager. I mean, the best defense to a disability discrimination case is, I didn't know the person had the heart condition or the suppressed immune system. So we don't want the managers or the bosses knowing about medical conditions. This has all got to be administered through the HR department. Then the person would fill out a form. This is why I can't get it. And then someone in the HR department would be designated to shepherd these inquiries. They would go to the immunologist and say, this is what the person's claiming. He or she would say, oh, these are the medical records I need. Then we would get the medical records. And then they would go directly to the immunologist or the infectious disease specialist. And that person would then decide or adjudicate, if you will, the medical accommodation.
They really have to have a plan, sounds like, and they have to consult with experts that can help them to make informed decisions, because they can make decisions that could have an impact on someone's life.
Exactly.
Right.
And it gets trickier. And there are forms for this, I think, on the EEOC website on their religious accommodations. And because it's the religious accommodation test under the Civil Rights Act, which prohibits discrimination based on religion. And that doesn't mean it's a religion based on personal beliefs, strongly held personal beliefs. So you can't say, oh, I need documentation from your pastor at St. Mark's saying that the Catholic Church prohibits vaccinations in order to honor your accommodation. It's something much less stringent than that has to be weighed. And the only way that I've seen that some of our clients have been able to avoid these religious accommodation requests is by requiring, again, the medical records where the person has a long history of avoiding vaccinations. I will say 9 times out of the 10, when we've gone down that road and requested the medical records, we've seen the person had a long history of getting vaccinated for tetanus or measles or smallpox or whatever. And then the request was denied. But otherwise, it's very difficult to do it on a religious basis.
And I understand, of course, this is really much, much more intrusive than just vaccines. I'm sure many of you have had to contact trace. If you were to go get on an airplane and go to another state, you'd have to get approval, you'd have to document it. If you have COVID, you have to inform your employer of that. You have to have quarantines. All of, most companies have had policies around all these issues. And it's tough, right? Because in the beginning, any resistance was sort of shut down, but now people really feel like they're losing their culture. People aren't going into the office. They don't have the same kind of relationships. And so there is a goal of getting people back into the office. And in Texas, I think we're really blessed to have probably more of a push to do that. But I read in the last couple of days that 72% of the workforce in New York is not back in the office. They can't go back into the office. 72%. And so that has multitudes of other mental health issues. And, so it's sort of a real difficult thing with people that have good intentions to try to deal with,
Oh, no, that's exactly right. This balancing act and the starting and stopping each step of the way. And I just never dreamed that the last 2 years of my legal practice would almost be consumed with this issue of helping people try to navigate it. Some people really were strong believers and we just have to have a mandatory vaccination policy. Others were very big on the personal choice issue. And as you say, they really believed there was a risk to the health and safety. My God, what if we have a super spreader event? Some of these clients had client events where their business is getting people together and connecting people and having meetings and selling their product or getting their multi-level company, all of their independent contractors together for their annual meeting. This is the lifeblood of the
people were
company.
going to jail. I'm sure you remember the lady that owned the hair salon, went to court, and Judge Moyer, Dallas County Courts. And then some of you are probably M&A lawyers or transactional. COVID has found its way into merger agreements and stock purchase agreements and due diligence and what is a material adverse event and all of these kind of things. So I think it transcends all of the different practice areas, above and beyond just how do we deal with the workforce.
Because our time is limited on this ETS, I'm just going to leave it with there are penalties up to, if it goes into effect, there are penalties up to $14,000 per violation. Each state has its own plan. Texas doesn't have an approved plan by OSHA under the ETS as of this moment. Some states it might be lower, and I'll put all these slides will be up on the website of ACC. So that's not, I've skipped forward on some of the slides, but I did want to point out if it does go into effect, there are significant federal penalties that will vary by state depending on its arrangement with OSHA. what the amount of the penalty will be. But currently, the maximum penalty is about $14,000 per violation. So that would be a real problem in not complying if the ETS is affirmed or upheld by what's going to clearly be the United States Supreme Court. If you're thinking about preparing, or you have been preparing, then I wanted to spend just a few minutes that we have left on how to go about doing that. And many of you may have already been doing this. Before the ETS came out, many employers were asking, well, how can we get ready? And one of the first steps was to ask for copies of people's vaccination cards, because we didn't know. It was perhaps maybe 80% of our workforce was already vaccinated. And this was an important inquiry when employers were debating, should we make it mandatory or should we strongly encourage it? You know, if 80% of our workforce is already vaccinated, why do we want to make it mandatory if we don't have to? Because I did find with the employers that did make it mandatory, they always ended up losing at least 2 or 3% of the workforce. And sometimes I was surprised by 1 or 2 of the really key people that just simply refused to do it. It was an eye opener. So if they didn't want to go down that road, and they had and they could find out they had a large portion of their workforce vaccinated, this was great. So one way to start is to request the vaccinations and come up with a tracking system. And then you're going to have to figure out, you know, you have to come up with drafting this policy that starts with the direction in the boardroom. Develop a written policy that, at least right now, are you going to have it conform with the ETS or not? Is it going to be mandatory? And of course, if it's mandatory, it's going to be a problem to implement in Texas. If it's going to be weekly testing, vaccination mandate or requirements strongly encouraged. But if you're not vaccinated, then you're going to have to get weekly tested. All that's going to have to be written out. OSHA, you don't have to start from scratch. It has sample policies for either approach or a hybrid. Effective dates, again, this is tricky with the stay of the federal cases or with the stay of the executive orders, coming up with a mandate for implementing your policy. But again, if you're not in Texas or Montana, you could probably go forward with a mandatory policy at this point because you're a private employer. Pay for the testing and costs, even under the emergency temporary standard, employers are not required to pay for the cost of testing or the cost of the vaccination. Under the emergency temporary standard, you are required to pay for up to 4 hours of leave time for people to get their vaccination. And I believe it's up to a week of paid time off for an adverse reaction to a vaccination. Again, that's under the ETS if it goes into effect. The face coverings, you know, again, if the ETS went into effect, and you didn't have a mandatory vaccination policy, the ETS would require face coverings, except when you're alone, for the unvaccinated, except when they're alone in their office, for a limited time when eating or drinking in the workplace, for identification purposes, when an employee is wearing a respirator or a face mask, when it creates a hazardous condition wearing the face mask. So generally, if you're operating under the ETS and you're unvaccinated, you have to have that mask on at all times. So it's another kind of policing requirement that falls upon the employer. The ETS requires giving employees notice of its requirements. You can find there's a good things to know about COVID vaccines at the CDC location. The ETS does prohibit retaliation against an employee who reports an unsafe workplace condition having to do with activities of not being vaccinated, being unvaccinated, some COVID hazard. If you need any assistance coming up with a testing provider and tracking testing, the U.S. Department of Health and Human Services has an online community-based testing locator. It has leads for contacting health providers and other vendors to determine options for complying with weekly testing and identifying systems for tracking and retaining test results. We've got a few minutes left, John. Should we, I think we reserve some time for questions. Sure. Yes, ma'am.
If the ETS is, if the stay is lifted, what are you thinking in terms of what timing will employers have to fully implement the ETS?
It was before this implementation was extended to January 18th. Now, it's been stayed now since November 15th, basically, or 16th. And I think it just looks, and remember, you didn't see this slide, but there were many challenges filed to the ETS. The Fifth Circuit just took up the first one. It issued a stay, an emergency stay within 24 hours. Because all these other cases were filed challenging it, the Fifth Circuit, they had to be consolidated somewhere. And that procedure for consolidating it was the cases all go into, at least all circuit identifiers go into a barrel. Somebody pulls it out. The Sixth Circuit drew the consolidated cases. Now, the Sixth Circuit has had it since around November 18th and has done nothing to change the Fifth Circuit's stay. The majority of the Sixth Circuit are GOP appointees, and I'm not saying that, I'm not making a political comment on that. I just don't, it's not like the Ninth Circuit where they might have been more aggressive in lifting the stay. So I don't get the sense that there's going to be any lift of the stay. And even if the court decides favorably or unfavorably, it just looks to me like it's headed for the United States Supreme Court. You know, we have the Jacobson case, Jacobson versus Massachusetts, 1905. The city of Cambridge wanted to vaccinate its citizens for a smallpox outbreak. And the United States Supreme Court, 1905, Justice Harlan said, perfectly lawful. It's not a constitutional violation. It's not a liberty. It's a violation because it's part of the police powers that are conferred on the states. So, but it was limited to the city of Cambridge. And here we have about 84 million people that might be affected by the mandatory vaccination mandates for 100 employee plus employers. So that gets more
Well, it's
complicated.
also consistent with the Constitution and the rights that are not specifically enumerated in the federal government or reserved the states. So you don't have the federal government mandating.
Exactly.
And
And when I look at the briefs,
municipality.
you know, on these challenges, the constitutional arguments are secondary. The primary arguments are exceeding the powers under the Procurement Act and violating the Administrative Procedures Act in terms of notice and comment. And again, the president has this power to regulate procurement, but this is something, this law is something much broader than regulating procurement. It's really something that would have to be done, the briefs argue, congressionally under the Commerce Clause. If Congress wanted to weigh in and issue sensible law under its ability to regulate commerce, and then assuming it could create a law that wasn't unconstitutional because of over-inclusion and under-inclusion, then it may be done.
But in terms of precedent of that case, I would suggest the U.S. Supreme Court would not find it controlling.
Exactly. I agree
Yeah.
with that. It's not
Yeah.
the last word. It's just the beginning, you know, just the beginning. Yes, sir. Thank you. The question was there anything in the governor's order, any other sort of legal impediment to providing financial incentives to encourage a broader group of the workforce to get vaccinated. And in my experience, the answer to that is no. There's no impediment. I think it's a great idea when you're figuring out these policies. If you're going with a voluntary policy, you're trying to get the, let's say you've discovered, because you requested copies of the vaccination cards, that 50% of your workforce is vaccinated. That's a pretty good number. And it may not be, ideally, you might want to get to 75, 80%. That'd be a home run. This would be a great way to do it. I've seen people, as you say, the $50, the paid time off to get the vaccination. And I had a client who offered 2 additional days of paid time off for people who were vaccinated. And that seemed to be, and then of course, oh, by the way, if you're not vaccinated, then we're going to go to the weekly testing. And that really, in my experience, was the biggest incentive, because I've seen people refuse to get tested. I mean, I've seen people refuse to get vaccinated, but I've seen people said, look, I'm not getting tested anymore. I'm done. You've been doing this every month or every week, and it's just too much. And so we've had to let some people go who refuse to get tested. So I don't think that for something about that testing procedure that people don't like, that can be a big incentive. But again, I see the headache of administering it. But the financial incentives, paid time off, anything else you can think of, you're only limited, as my old boss used to say, by your imagination on that, as long as it's offered to everybody.
Doug, what about labor unions? Do they weigh in on these issues? Are
yes.
they getting sick of being told what to do, or?
Oh, no, that is outside the scope of our presentation, because you could do a whole presentation on labor unions and their business. It's no
So
different.
it's an
than,
issue.
it's no different than the government
Yeah.
contract issue, because
Yeah.
it's got to be collectively bargained. You could not implement it unilaterally.
They want their own incentive.
Yeah.
If there's one last question, we'll take it. Go ahead.
The question was, how long would you put an employee on unpaid leave if they were in violation of the policy? Now, that's an option, but because my response to that initially is, most of these policies have said, oh, if you're not vaccinated by X date, then you're terminated. Is there some special circumstance why you might be thinking about an unpaid leave? Although the federal government, by the way, has done that.
Yeah, I think just to encourage them, it was just a.
Gotcha.
Potential accommodation.
Yeah,
That's the.
It is.
I'm not gonna fire you over the accommodation, or a medical accommodation, or religious accommodation. Would be, I'll give you a 6-month leave or 3-month leave or whatever. Think about it a little bit more. Or if it's a medical one, and maybe it's a temporary condition that they have that they can't currently take it, then you might get it without. So that's.
Sure. I see. Well, like I said, if it's a religious accommodation where we can't require it, if it's medical, then you're right, it's going to be limited to the time period of the condition. We'd have no discretion in that regard, unless the accommodation posed undue hardship, or the person said, oh, I've got this condition and I can get vaccinated for a year. And we're like, well, we can't let you in when we can't have your position empty for a year. Then I think we go ahead and terminate that person. Now, usually the problem with accommodations, the argument I always get back when I suggest to an employer, oh, we put this person on unpaid leave of absence, like, well, how do we, if we hire someone to do their job duties while they're thinking about the vaccination, what are we going to do when they say, oh, call back and say, oh, I've decided to get vaccinated? So that's a real problem. In the federal government, I noticed they were not immediately terminating people, but remember, if you work for the federal government, there's an administrative process generally that you have to go through to get fired. You can't be fired very rarely on the spot. And so I thought that was part of the process. The federal government were putting on people on unpaid leave while they work through the administrative process concerning their terminations. So it's an option, but I just think very few employers could actually accommodate a large number, even a handful of positions that came forward and said, oh, I understand you're putting me on paid leave because I need more time to think about this vaccination. The people that I've seen that went with the mandatory vaccination policy They just set it out as far as they could, the drop dead date. And then kept reminding people, oh, you only have 3 weeks to go, and we're not seeing any evidence of your vaccination as of yet. Oh, this Friday will be your last day unless we get evidence of your vaccination, Oh, today is today, and you haven't gotten it. So, Helen from the HR department will be coming to your office at noon.
Yeah.
Yeah.
But I think that's starting to shift a little bit, I mean, people were complying because they felt helpless. And I think that the attitudes are opening up to different opinions now.
Yeah, no, I mean, I generally do not recommend the mandatory vaccination policy just because it's so difficult to implement. You just end up having to fire a large people. We're in a job market where unemployment is 2.9% and there are 11 million job openings. It's not so easy to replace people. So absent the ETS being in effect, and you have to, or you're in one of these localities in California or New York where you're mandated to have a vaccinated workforce, I don't recommend it. I think this encouraging people is the way to go, coupled with some periodic testing.
Well, we really appreciate everyone coming out today, and we hope to stay in touch with you. I think our cards are up there, and we sponsor ACC, I think, in 9 cities. So we're pretty committed to the group. And, we always like to just continue the relationship. And obviously, if you have any questions about this, you can reach out to us and we'll try to be a resource for you. So we thank everybody.
Thank you. Yes, the slides will be on the site.